Hey everybody, welcome to our weekly immigration podcast. We cover all things immigration in the United States and try to give it to you as fast and cleanly as possible. This week we're going to talk a lot about F1, OPT, and student visas. We have a lot of questions from you guys. It's a topic that's very, very popular. So in response, we're going to do this episode mostly about student visas and trying to hit the questions you guys have posted for us. In addition to that, we're going to cover premium processing. There was an update on premium processing. Phase 1 has started. Also, we've got a little bit of information for you on a Supreme Court opinion that's pretty big in immigration. We'll give you our opinion on that and get you going. And then we'll hit all the student visa questions that you guys have listed for us and give you some updates on some of the information we have for you. All right? Things will be timestamped below if you want to jump ahead. And of course, we always appreciate you watching. Give us a thumbs up, subscribe, share it with your friends because we do this for free, love doing it, and we're here for you. Our first story today is about premium processing. As you may know, USCIS has a specific type of processing called premium processing. It's an extra fee and it allows certain types of cases to pay that extra fee and get an answer in 15 days, okay? Now, premium processing has existed for a long time, and the simple fact is USCIS has made a lot of money off premium processing. Today, the premium processing price, I believe, is over $2,000, okay? So it's a very hefty fee, but getting that 15-day response is very, very important. Earlier this year, they announced that they're phasing in new premium processing applications, okay? In the past, it was limited strictly to the I-129 and different kinds of cases that are filed on the I-129. The I-129 is the work visa, H-1Bs, E-visas, other types were filed on the I-129. So they've announced that they're going to be expanding and doing more premium processing, and their recent announcement is very, very specific. In fact, they announced that Phase 1 is going to be beginning on June 1, 2022, where they'll be accepting specifically the I-140 petition for multinational managers. Now, that's called the EB-1C, okay? That is individuals who are working as executive managers in the United States, typically on an L-1A, who then file for the green card in the executive manager category. Now, this category has no perm process. It's very simply a category that is a petition filed by the employer listing all the information and what's going on. So that category, and I'll tell you, I've got clients in that category that have had cases pending for 10 months, 9 months. In some cases, we were going into 14 months, just waiting for a response. And frankly, in the business world, they can't wait that long. So it makes sense that USCIS will be bringing in the first group on June 1st, 2022 to file for the multinational executive and manager positions. They similarly announced that on July 1, 2022, 1 month later, they're going to also accept the NIW. Now, the NIW is a national interest waiver. It's an EB2 category case, and it applies for individuals who believe that they don't have to do a perm case. They can do the national interest waiver. Again, a category where people put a lot of emphasis in their success in the work they've done and the work that they are doing in the United States and how it benefits the United States. And when they have to wait 6 months, 9 months, or more than a year as we've had recently, it doesn't make a lot of sense. So that is the second category that will be getting the benefit of the premium processing. Okay, so multinational managers, okay, that's the EB-1C category, and the NIW will both be getting premium processing starting June and July this year. Great news. If you're out there and this is for you, take a note and talk to your lawyer about getting ready to file that, all right? In our next story, we've got a Supreme Court decision that came out recently. It's called Garland v. Patel. Now, Garland v. Patel made essentially a highly legalistic determination and ruling. Essentially, but the facts of the case, okay, like the story behind what happened was really kind of tragic and sad. But the legal result really fits in with what we already knew to be the law in immigration, but it really highlights for you how immigration law can be kind of narrow and not make a lot of sense. So let me explain. Patel was living in Atlanta, Georgia, and at some point in his life, he got a driver's license, and he says he mistakenly checked the citizenship box. Now, he just was trying to get a license, and he was at the place filling it out, and he just checked a box without thinking about it. When he ended up in immigration court fighting a different kind of case, the prosecutors pointed out, hey, look, he claimed to be a citizen, and under immigration law, a false claim to citizenship that wants to get an immigration benefit is a permanent bar, meaning you are never allowed to get a green card once you do that. Okay, so it's a very strong violation, the false claims to United States citizenship. And we look for it all the time when we talk to people about their paperwork and what they've done. Now, in this case, he pointed out it was a mistake, and it seemed like in court people believed him, but nonetheless, the judge ruled against him. All the appeals, it took 10 plus years, it got to the Supreme Court, and the Supreme Court said the exact same thing. They said, look, he may or may not have made a mistake, but the judge at the time said he has a false claim to citizenship and he can't get the green card. We're not allowed to look at whether he made a mistake or not. We, at the Supreme Court, are not allowed to review that because in immigration law, they found back in 1997, they changed the law. And they said that you can't appeal every case into the federal court system and into the Supreme Court. So it was done on purpose. Congress wrote this law in 1997, and we all know it. In fact, we struggle with it all the time. What it really comes to point out is, number one, immigration laws are somewhat unjust, right? They tend to be broad, and they tend to just be a big category, like we're not letting people make appeals. We don't want people going to federal court. That's what this rule is. But another part of it, which I think shows you where things can go kind of a little bit wrong, is that clients don't know this, but lawyers do. And when lawyers start to make strategy decisions, or lawyers tell you we have to do this or do that, or tell you whether your case is going to be good or bad, because I do this every single day, and I point actually this kind of thing out to people all the time. And I say, look, you've done this, and the simple fact of the matter is if it comes up in court, we may not be able to fix it, okay? This means when you go to court for immigration purposes, you really, really, really need to have an attorney that's looking at all these things and giving you good advice. The whole semi-professional world of immigration law, where notarios or people that process taxes or divorces, then advise people on immigration, and that's a very big part of the Hispanic community, is actually full of these kind of mistakes. And I cannot tell you how many cases I see every day where people have done something completely wrong through a notario, and it's too late to fix it, okay? So, Garland v. Patel, really stinky case, really hurts this guy. And the simple fact of the matter is the law is closed on this. What you need to think about is if you're going to immigration court, you really, really need to keep in mind you want an attorney to have a full view, you want a lawyer who knows immigration law, and you want to make the best case possible, okay? And you want to be advised of these things before you even go to court, okay? So Garland v. Patel, bad case, did not like it myself, but I've also been aware of these kind of cases in the past, and it's sad to see a case go all the way to the Supreme Court and lose. All right, let's kick it off with a little bit more information on student visas. Now, student visas are the F1, okay? The F1 visa, it's a visa which you get from being admitted to a school, applying at the consulate, and coming and attending school. With an F1, you must be a full-time student attending school the entire time. Just to give you an idea of one of the major issues that comes up, I want to bring up to you something very simple. It's called reinstatement of status, okay? So reinstatement of student status is one of the biggest problems students have when they become ill, fall out of status, or for financial reasons or problems back home, end up not doing well one semester. There is a provision in the law called reinstatement of student status, which can be used to bring you back into school, back as a full-time student. The big deal here is you have 5 months. 5 months. It's the biggest thing in the world. Keep it in mind. Reinstatement of student status. If you have a problem and you run out of status or you fail to attend full-time school, you can be reinstated to student status, but you have to act quickly. I recommend students who are in the United States and have problems, contact a legal attorney immediately. You never know if this reinstatement is going to work for you or not, because another trick is changing to a new school, but we can get into that as we go along. So reinstatement of student status is my tip of the day for any students out there. Keep it in the back pocket in case you need it. Tell your friends about it if they have a problem. It's a good way to get your things fixed. Our next topic on student status on the F1 topic today is the OPT employment tracker. Now, USCIS has an actual page just set up for individuals who are on OPT to be able to look in and check what the SEVIS system has for them, okay? So let's get into this. Post-completion OPT is the 12 months after you graduate, you get to work, okay? In post-completion OPT, you're only allowed 90 days of unemployment. 90 days of unemployment, all right? Now, STEM OPT, which is another program after post-completion OPT, it's an additional 24 months, has 150 days of actual unemployment. Now, this is very important because I have calls all the time about this. What's going on with my status? I was unemployed for 30 days. How does the government know? What do they know? How can I get back into status? Where can I check my status? Okay, so take a look at this pop-up that we've got up already. This is the unemployment counter, which is found on the Department of Homeland Security's website in the Study in the States section. In the Study in the States section, they actually lay out for you very clearly what you're allowed to do, the 90 days, 150-day rule, and then they have a way for you to log in and check your unemployment counter. Now, this is actually really, really important because when you become unemployed, your employer needs to report that, okay, to the to USCIS or to the DSO, right? And if they don't report that or they neglect to report that, you might be in limbo. Okay, you want to always know what the official word is. If the official word in this website says you're employed, you may need to talk to your student officer, your DSO, and tell them, hey, I'm unemployed. Okay, this is a very tough decision that you have to make. And getting involved in this system, it's important to know where the information comes from, what your total limits are, and where you stand on those days and the counts. Okay, because on STEM OPT, they actually say the 90 days that you might have used in the prior OPT will count in your STEM OPT. So it's not always a pure 150. It might be a whole different counter, okay? So what you need to do is you need to really check on this unemployment counter. It's a great link. It's a great resource. And if you don't know about it, here it is for you guys. Check it out. If you have any issues with OPT and you want to know where you stand, take a look at this first, but of course, also talk to your attorney. All right, we got some questions that come up all the time, and one of them is, can you renew your OPT? Okay, so USCIS has specific regulations in OPT, and I would really recommend in your graduation year you get familiar with those rules, the timing of when you can file. And the simple fact is that any OPT must be filed within 60 days of the OPT STEM recommendation, and 90 days after graduation for post-completion OPT, okay? So there's specific rules there. And the truth is, in my early days doing this, these rules were a little bit different. You had to file before you graduated. I had a general rule, and I would put out information to any students that I work with, which is in the 3 to 6 months before you graduate, you should start working with your DSO. And within 3 months of graduating, if you have a date of June graduating, you should be in March. You should be at the International Student Office getting ready to file your OPT. You should know how to file it and know what to do. There's online filing and there's, of course, mail-in filing. All of that needs to be sorted out, and you need to be careful about it. One small mistake and you can lose months and months of OPT time and perhaps miss out altogether on working, okay? So the question, can you renew your OPT? OPT has a timing limit. It's very narrow when you can file. If you miss that filing date, you will not get post-completion OPT. Okay, so let me be very, very clear. If you miss the timing for an OPT filing, you won't get it. There is no I want to file it late and get it now. It's never existed that way, and you need to be aware of those times and those dates. So you cannot renew OPT. You must file OPT on time, and it's the same for everybody. Post-completion OPT is 90 days. STEM, it's 60 days. Okay, so to close up, we'll cover a lot of the questions you guys have. There's a lot of questions about OPT and F1s, and we'll try and answer the best we can. Here we go. I'd like to thank you first. Well, you're welcome. Thanks. I'm going to apply for F1 visa. I would like to know if the university ranking affects the approval of the visa. All right, good question. Does the ranking of a university affect the approval of the visa? Now, this becomes a little bit more of one of the factors that are in consideration by the official at the time of your interview. And I would break it down into some very simple explanations or tiers. If you're going to, let's just say, one of the top 25 schools in the United States, from Stanford down to, University of Washington, let's say, okay? There's so many in between there, okay? Including Ivy Leagues, UC schools in California. If you're going to some of those top tier schools, I think it does affect, okay? It definitely shows that you have been successful in getting into one of the best universities, perhaps, in the world. These are world-renowned universities: Stanford, Yale, Harvard, Berkeley, and many of the Ivy Leagues as well. UCLA falls into that category as well. And then below that, there are a whole tier of schools that are very well known. And then when I look at it in below that, I'd say there's 3 tiers, which is the group, tier 2. But tier 3 would be schools that are less known, okay? Less known, perhaps not very well known, and the officer may not have heard of it, may not know much about it. If you believe you're in one of those lower tiers of schools, okay, it is your responsibility to be very, very well versed on the school, where it's a little bit of its history, what it excels at, what its graduates do, where they go. So for example, there are schools here in California that nobody has heard of. So the Clarence, the McKenna colleges here. They're very popular, very well known as a liberal arts school here in Pomona, just 50 miles or 60 miles away from Los Angeles. While those schools are very, very well known and are prestigious in their own way, you would want to know more about those schools and be able to present things about them. For example, another school locally is Occidental College. Now, Occidental College is a small university here in Los Angeles, again, close to the McKenna colleges. And Occidental is famous because Barack Obama went there for a year. That's it. Okay? And something like that might be important. It shows that it has some prestige or some connection, what its alumni have done and what people have done. By all means, knowing about your university when it's not one of the top 25 or 50 is going to be very, very important. And I think you should practice articulating in a 2 to 3 sentence answer why you chose that school or why you look forward to going to that school. Okay? So, does the ranking affect the approval of the visa? It's one of the factors that's in there. And if you believe that your ranking is perhaps not one of the best schools or most well known, it's your job to come up with a good explanation about why you're going to that school. Okay? Very, very important. All right, next question. Please, sir, what are all the documents that are needed at the F1 student interview? Well, that's kind of a broad question with a lot of things in it, so I'll just hit the major points. Remember, when you do an interview like this, you've already submitted your application online. Your responsibility would be to go to the interview with a package of paper. And in your head, you need to know all those papers, and you need to be ready to show them where things are. Typically, you need your entire educational history, okay, your grades if you've gone to university, your transcripts showing that, your graduation from secondary school. You need to show your history. Those are the big factors. The next part is going to be the money. You need to show the money, where it comes from, where it is, and how it exists, and how you plan to pay for everything. On top of that, I think it's really important for students to show either a resume or a series of accomplishments, things that might be interesting so that the officer can ask questions and you can kind of feed them about why you're a successful person and things that indicate you will be successful. I was the president of such and so club. I was on the debate team and we won debates all over this part of my country, okay? All those small things may be helpful for you. You never know what an officer did when they were in university or where they were in school, and they may catch on to that. So be aware that you are fishing, trying to catch interest and show what you've done. So outside of the documents listed by your school on their website and in their letter to you, and from the attorney who helps you with it, outside of that, because I'm not going to make a list for you, you need to come up with things like a resume or things that show your interest or your accomplishments, because that's going to be maybe the key to unlocking an approval. All right? Another question here. Thank you so much for your information. Could you please elaborate on the importance of scholarship awards for F1 visa acceptance? All right. Look, I've been through so many visa F1 things. I have had people admitted for school with a scholarship get denied. I've had phone calls from all over the world where people told me, oh, I've been admitted and I have a scholarship, and they told me I still can't go. So, again, at the F1 interview, a scholarship is important, okay? It's important in the monetary part of it. Okay, and sometimes scholarships are based upon having a certain GPA or being in certain academic standing. Well, the officer might question you on that, and you might want to point out to them that, hey, look, I've got financial support outside my scholarship. See, my parents have this much money to pay for the whole year, even though my scholarship pays for half. I mean, scholarships aren't necessarily going to just give you the actual F1. In fact, the officer may question whether that scholarship will last throughout your 4 years, right? The officer might question if it was a one-time award or how that scholarship is reevaluated yearly, right? And you need to know that, and you need to know how that fits in and how you can then convince them of how things work. In this instance, what I would always advise my clients is, again, you always need a 2 to 3 sentence answer explaining your position. And that should be something like, you know what, scholarship, you're right, the scholarship does require a minimum of 3.0 GPA, and I want you to know that I've had a 3.9 GPA throughout my secondary school, and I've never gone below a 3.5 in any given semester. I feel confident that I will have a 3.0 GPA and continue to get this scholarship, okay? That kind of answer is what they're looking for. They're looking for the confidence. They're looking for the people who actually can stick up for themselves and explain why they will be successful in school. Remember, the F1 visa is an evaluation of will this person go to the United States and attend this school, and will they be successful there? Will they complete it? Of course, there's the return home part and the ties to the home country, which is another part of the F1 visa. Our final question today is, I was denied a J1 visa about a decade ago. I now work in a different country. I'm going to apply for my F1 soon. Do I have to indicate that I was refused a visa when I was doing my J1 visa? All right, bottom line here, whenever you're doing the DS-160 or any form to the US government, I would advise you to always tell the truth. The question here would only be, so that means you would say, yes, I was refused a visa once, because it did happen. Sometimes these questions can have gray areas, and that's when you discuss with your lawyer what the gray area might be, okay? So, for example, I have people who have been arrested for a crime and then had that crime expunged and thrown away, and therefore their record was totally clean. For some of those people, I have to tell them, well, you have to answer yes that you've been arrested, because if they ask you, have you been arrested? But if you've been convicted of a crime, you'd say, no, I have not, because I saw a judge and he threw the whole case out, all right? So, for the most part, you're going to want to look at answering your questions as quickly as as best as possible, as truthfully as possible. And in a case like this where it says, have you been refused a visa, you're going to have to say yes, okay? So I know that might hurt your chances, but being honest and being clear with them is the way to win that visa and overcome that past refusal. That's it for today. I covered a lot of stuff I wanted to go over with you really quickly. We talked about the F1 reinstatement. We went over the employment tracker. We talked about filing for OPT, and then we answered all your questions. So lots of F1 content. Leave your comment below. If you've got more questions and you want to know more, we can do a full episode on just F1s, because a lot of you guys are out there struggling, trying to make sure you get this visa granted, and you work really hard for it, okay? So we're happy to help you with that. Thanks for making it to the end. Thumbs up, subscribe, like, whatever it is you can do for us. We appreciate it. And stay safe out there. Thanks. Bye.